Hi, welcome back. I wanted to talk about copyright infringement, and more specifically, I wanted to talk about the defense of fair use. It's a very important defense, and it's important for a wide variety of reasons. The main reason why is because with fair use, what courts are trying to do is balance between the rights of creators of copyrighted materials and the rights of, if you want to call it, copiers or imitators, right? Yes, the standard for infringement is substantial similarity, or just basically copying somebody else's work without authorization. But but copying doesn't always generate a copyright infringement liability. Copying somebody else's work or using a substantially similar work because of the fair use defense. Now, what I want you to know about the fair use defense is that it's not a bright line rule like strict liability or a speed limit. Fair use is a general standard because it consists of four different factors. And what the courts have to do is weigh each and every one of the following four factors in order to determine whether the alleged infringement constitutes fair use. In other words, whether to allow the infringement, allow the use. Now, here is a common misconception the public makes, to think that, and you'll see this sometimes, like I've seen this at various, even at the university and at various employments, like, only use maybe 10% of a copyrighted song, play no more than 30 seconds, or only copy up to 5 pages. Fair use doesn't really work that way. It's not formulaic at all. So let's go over the four factors. One is you have to look at the reason why you're infringing, or the reason why you're copying somebody else's work. So I'll give you a good example. If your purpose is educational in nature, right? Or if you want to do a parody and criticize somebody else's work, or you're writing a book review or a movie review, and you want to show a short film clip, or cite a paragraph in the book that you're reviewing, or like I do, show videos or theme songs of copyrighted stuff to make the class more interested, right? Or just take stuff, from Tiger King to make this class a little bit more engaging, given that we're not face-to-face this semester. Well, generally speaking, if that's your purpose, right, that would be considered good, fair use. But guess what? It's only one factor. Just because you're doing something for educational reasons, or to parody somebody else, or to write a review, doesn't mean that you're automatically off the hook. So let's look at the other three factors. The other second factor is the nature of the copyrighted work. That is to say, the work that you're copying or stealing, so to speak. So the idea here is, if you're stealing something that's commercial in nature, as opposed to something that is, maybe has some educational or artistic value, maybe it's more likely that you're going to be found not in fair use as actual infringement. So we have to look at not only the reason or the purpose of why you are allegedly infringing somebody else's copyright, we also have to look at, well, what is that copyrighted work that you are, allegedly infringing? Third factor is the amount of the copyrighted work that you're borrowing or you're taking, right? The idea there is a sliding scale, right? The more you're quoting of the other work, the more pictures you're stealing off the internet, or the more of the song you're playing, right? The more likely you're going to be found not in fair use. You're going to be found as an infringer, right? Even though you want to argue that it's educational and the nature of the work is not commercial. But guess what? You have to look at all the factors. And fourth and finally, remember, it's four factors. Fourth and finally, I would argue probably one of the most important of the four factors, although the courts don't really specifically weigh the factors, but courts generally give this fourth factor I'm about to talk about a lot of importance. The effect of the allegedly infringing use, the effect of the use on the market or the potential market of the copyrighted work that you're borrowing or stealing, as the case may be. To understand that fourth factor, let me take you back to '01. Napster. Napster, at its height, had 26 million users, which is just an incredible, mind-boggling amount of users for a company that began in June of 1999. Even Facebook, it took Facebook over a year or about a year to get 1 million users. And that was one of the fastest growing companies, that we've ever seen. So Napster was just mind-blowing. And the way Napster worked is that when you signed up for Napster, you would have to upload a certain computer program that would have access to your MP3 or digital music files. But by signing up for Napster, you would have access to the music files of all the other Napster users. And so what happened is eventually Dr. Dre and Metallica brought 2 lawsuits. They brought the first lawsuits against Napster for unauthorized use, of their music, of their copyrighted music. Now, the irony doesn't really, escape me. Now, of course, Dr. Dre and Metallica, they actually have their own YouTube channels, But back then, YouTube didn't come around until 2006. Napster was new. A lot of people now are, what's going on in '01? Nobody is buying compact discs anymore, let alone cassettes and, vinyl records. Back then, compact discs or CDs was the way a lot of music was distributed. And so if you wanted music, you'd have to get a compact disc or get somebody else's compact disc and figure out a way of burning that compact disc. With this new MP3 technology, where you can actually convert music into a digital file, Napster kind of built its business model around that. And now this raises an interesting question, which I will address in my next and last video. How is it that, because what happened to Napster? The court said there, and because, actually, I shouldn't assume you know what happened to Napster. The courts actually, because they uniformly ruled, and this went up to the Supreme Court in a subsequent case called the Grokster case, which is in your textbook. But ultimately, the courts ruled that what Napster was doing is not fair use because Napster was having such a negative effect on the commercial sales of compact discs. And this raises a really interesting question. Well, how is it possible that, and so what the courts did, I just cannot, this is very important, very important. I can't emphasize it enough. The courts ended up basically, for all intents and purposes, shutting down Napster. How? Well, what happened was after Dr. Dre and Metallica won their respective lawsuits, the Recording Industry Association of America, or RIAA, brought a lawsuit on behalf of basically all of their musicians and composers, which really covers, 90% of the musical market. And they asked the court to say, look, this is not fair use based on these previous cases. Please issue an injunction, a court order, telling Napster to take down all unauthorized music files on their platform. And so that effectively pretty much brings an end to Napster. Now, how can it be though that YouTube, right, is, very similar business model, right? People upload stuff on YouTube and YouTube is accessible to everybody else, right? In fact, with YouTube, you don't even have to download any programs, just a web browser, right? How is it possible today that YouTube is perfectly legal while Napster was literally shut down by the courts? Well, we'll talk about that and I'll answer that question in my next video and then begin wrapping down this module.